you are the first person to join the conference.
Macek.
I'm sorry, what?
Macek.
Oh, Mr. Macek is here in the courtroom.
Okay, thank you.
I'll walk out if it's Frank.
Pardon me?
I'll walk out if it's Frank. I'm not Frank.
I apologize. I'm so
Okay.
sorry.
Jason, when you talk, make sure you talk to the microphone, just so that they can hear you okay.
All rise. Thank you, everyone. Please be seated. We're on the record for hearing because of PR 170018. In read the matter of Stephanie Frank petitioner and Jason Macek responded. Mr. Macek is present in court as a self-represented litigant. Is Mr. Flaherty with us remotely?
Yes, Your Honor. With present with Stephanie Frank.
All right. Very well. So I just want to get an outline from each side. Mr. Flaherty, what relief are you seeking today, and are you planning to call any witnesses?
Yes, Your Honor. So in the this harkens back to the real property award that this court had 25th of 2019, where Mr. Macek was informed not to divert any rent from the tenant and to stop interfering with any rental payments. And then then that was piggybacked onto the real property award, where it definitely would sell the house. Mr. Macek would be responsible for the damages during that time of his ownership of the rental. And then there'd be a division, an equal split of unreimbursed fees to repair the house if it's sold, and then profit sharing if their child support caught up at that time. And so the house is about ready to be sold. So I would anticipate, and so there's a few outstanding issues. Mr. Frank,
Mason.
or Mr. Macek, sorry, that at that time had the tenant put $500 of rent to his bail money, and then he has not returned the deposit for the bail, for the tenant security deposit. And so those two items need to be addressed. And then we have a bid from Paul Chu.
I'm sorry, we lost audio. Repeat that, you lost audio.
Yes, we have a bid from Paul Schuster, a contractor in town that was previously filed the exhibit, and I'll call him if need be. And he would testify to the damages of the house at the time that Stephanie took possession. And so that's $34,800. And then the new costs to get the house ready for sale are growing, and I have Stephanie testify about what her new costs are that would be equally shared between her and Jason. And then any leftover profit would be pursuant to the court's order, child support, and then distributed that way. So that's the items of relief I would have for the court, and I would anticipate calling Stephanie and Paul Schuster.
All right, and let me know the legal authority by which you're seeking that relief. Are you seeking that? Well, let me know what legal mechanism you have in mind so that Mr. Macek can respond with his position legally and factually.
Okay, so the previous court order from the bench on March 25th was that Mr. Macek should stop interfering with rental payments from the tenant, and his refusal to hand over the $1,800 deposit and the $500 that he asked for bail money from the tenant after that hearing, I would seek that either through contractual or since it's a court order through the civil contempt power. And then as far as the sharing in the cost of the home and what is attributable for him, that March of last year property order on real property that this court issued spells out how those costs are shared for the marital home, and so it would just be under the seeking to enforce that court order and make those costs attributable to the right persons we can allocate it, so when this thing closes, we know how much is awarded to Stephanie and or Jason. So it's under that under the Article 2 is enforcing the court orders.
So you're basically, it sounds like the first two items you're seeking under a theory of civil contempt, and the third one you're looking at as enforcement of the pre-existing order. Is that correct?
Yes, that was much more distinct way, I'm sorry.
Well, I just want it to be clear, and then I can listen to the other party and listen to what his position is on those points. So,
Yes.
Mr. Macek, were you able to hear what they had to say?
Most of it.
And what is your position on, do you agree with them, or do you disagree, and what is your legal theory, and do you have any testimony you're going to present today?
Yeah, this is just still a continuation of the fraud, waste, and abuse case that you've overseen since 2017.
Well, I don't necessarily
No, there's no
know what
well.
you're talking about. This is a family law case.
Exactly.
It's not a fraud, waste, and abuse case, so,
Child abuse,
well,
tax fraud.
there's nothing about child abuse at issue in this case.
Okay, well, there's my answer.
Well, you're representing yourself.
I am.
You do still have to
Sure.
Are you going to be your own witness, or do you have other witnesses here?
When I gave a list of witnesses for the DDR to 17-0018, those were all ignored. I never received a witness list from the plaintiff. That was ignored. Fraud, waste, and abuse. Thank you.
All right, well, you're making your record. Mr. Flaherty, you can call your first witness.
Okay, thank you, Your Honor. I would first call Stephanie Frank to the stand.
And I would object to that. I didn't get a list of the witnesses. Yet again.
Mr. Flaherty, Mr. Macek is objecting that he hasn't received notice of your witnesses. What's your response to that?
In the motion for relief, there wasn't a prior court scheduling order that would require me to disclose that. But in the motion for relief, I spelled out that Stephanie needs repayment for these expenses, and it's reasonable to conclude that she's going to indicate those expenses.
All right, I'm going to overrule the objection as to Ms. Frank's testimony. She's a party on the case, and we all know what the issues would be, so I think it's clear who the witness would be on that point. And I'm not going to prevent you from testifying just because you didn't give a witness list, so my rule applies across the board. Both of you can testify today. We'll have a fair hearing. Mr. Flaherty, you can continue.
I object to that comment. Fair hearing.
All right, what's the grounds for your objection?
The comment of saying this is a fair hearing.
Well, I know that's your objection. What's your legal basis for saying
Fraud, waste, and abuse.
based on what?
DDR 2017-0018.
Well, I'll note for the written record that I have given you multiple opportunities to state your case. I've given you multiple continuances. I've shown you nothing but respect as a self-represented litigant, and I'm going to extend that again today. And you're allowed to continue making your objections. I'll rule on them one by one, and I'll listen to your argument on every one. But you've offered no evidence of fraud, waste, and abuse. That's your opinion, and you're entitled to your opinion in the United States of America. You have no evidence for it, but you're allowed to believe what you want to believe. You have freedom of conscience in this country. Mr. Flaherty, you can proceed.
Okay. All right. Stephanie, will you raise your hand and be sworn in?
You do solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you.
So, Stephanie, the court's familiar with your case, and we've been in front of this court several times, so we don't need to go over too much, but I want to focus on when you took over renter for the marital home, and you had renters that inherited from Mr. Macek. Do you recall those renters?
Yes.
And what were their names?
Tracy and Russell Damaris.
Okay. And previously, Mr. Macek testified that he had a month-to-month oral lease, and he wasn't sure how many people were living in the house at that time. Do you recall that?
Correct.
And so when you took over, did you try and tell them to get rent to you and otherwise pay only you?
Yes.
And that wasn't happening. We had a hearing on that, and you testified on March 25th, 2019 about the lack of rent payment. Did you eventually get rent from those renters for that after that hearing?
Yes.
Was it full amount of rent?
No, they were short $500 of the rent because they said they gave that $500 of it went towards bailing Jason out of jail.
Because on March 25th, Mr. Macek was incarcerated,
Yes.
and your renter was instructed. Do you know who instructed him to pay that $500 bail money?
I object here. Say whatever she's going to say.
Okay, one moment. There's a hearsay objection. Can you repeat the question, Mr. Flaherty?
Yeah. Do you know how you know that the rent went to Jason's bail money?
Tracy told me.
Well, what are the grounds for admitting that? Because that would be a hearsay statement, so I'd be inclined to sustain the objection absent any
I'll withdraw the question, Your Honor.
All right. So your objection is sustained as to hearsay. Mr. Flaherty?
Okay, so, so that month you only received $1,300 in rent?
I object. There's no evidence of that.
Just one moment. Mr. Macek, what are the grounds for your objection?
There's no proof of that. Deposit, anything of that. That's yet again just a number that's made up.
Well, what we're doing now is taking evidence. I'm going to allow argument later as to what it means, but I don't hear a basis. I don't hear an evidentiary reason I would shut down the statement as I did with the hearsay objection. So you'll have a chance to argue what you think is accurate and what isn't later, but I'm going to overrule your objection for now. Mr. Flaherty.
So, Stephanie, you eventually got the rent, but it was short.
Yes.
And the condition of the home when you found it, we bought some exhibits here labeled, before pictures. Do you know who took these pictures?
I took them myself.
And, before we go on from this, did you ever receive the deposit back from Mr. Mason?
No.
And what was the amount of the deposit that was previously testified to in this case by Mr. Mason?
$1,800.
And you've asked Mr. Mason for that through
Yes.
counsel?
Yes.
Have you ever?
I object to that. There's no proof of her even asking me.
I'm sorry, there's two things at issue. Number one, the audio feed is cutting out, and the court needs to be able to hear the material, and the other party needs to be able to hear it. So can you repeat that again, and then I'll entertain the objection and see whether it's sustained or overruled. Mr. Flaherty, please just repeat the last 1 or 2 minutes of what you said.
Okay. It was generally, Stephanie, have you received the deposit from Mr. Mason?
No.
And if you communicated with him or through counsel or through personally, have you had any response from Mr. Mason about the deposit?
I object to that.
Okay, one moment. So Mr. Macek is objecting, and I want, what are the grounds of your objection?
To the answer, well, I guess that would be a lie
Well,
to the response.
you're allowed to argue later about what you think the truthfulness of the statement is, but in terms of whether it's admitted, that's just a different question. So I'm going to overrule your objection because there's no evidentiary reason to do it, but you're free to argue what you think is truthful and not at a later time. But you'll have to argue it based on your own testimony, or I'll have to say facts not in evidence. So I'm going to overrule your objection, but that doesn't mean you're not free to argue that point later. You can argue that point later. So I've overruled the objection. Mr. Flaherty, you can continue.
Okay. So any indication, Stephanie, aware that Mr. Frank or Mr. Mason responded in any way about that deposit?
He never made it clear that he would ever return it to me.
And it's been almost over 1 full year since you requested that?
The last time I spoke to him about it was in February.
Okay. And this hearing would be in March 25th, you haven't received it, and it's been over 18 or 16 months.
Correct.
Okay. Moving on from the lost rent and the lost deposits, have you taken photos of the condition of the home when you found it? Would you repeat to that?
Yes.
And do those photos that we previously lodged, are they true and accurate representations of what you've taken?
Yes.
And I object to the photos because they have nothing to do with me. Those are on the renters. So if there's an issue that she's going to have money-wise, she's going to have to take that up either with the insurance company or with the renters. That has nothing to do with me.
All right, so I'm going to overrule the objection because this is about admissibility of the evidence, but your legal argument...
Which I object to because how is that even admissible? That's not me doing the damage.
So, within the Montana rules of evidence, there's a question of admissibility and a question of weight. Admissibility concerns whether or not a statement or an exhibit is in the record.
Whether lie facts or
Weight.
not.
I mean, a statement is evidence the same as a physical exhibit is evidence under the Montana rules. So, admissibility means
It could have been her.
Sorry?
It could have been her.
Well, you're free to argue that.
Okay. Okay.
And that's the way it would be if this was a criminal trial or,
Which it
well,
feels like, right?
but it's not.
Okay.
If it was criminal, you'd be entitled to counsel and such.
Yeah, I felt that one already.
Well, anyway, Mr. Flaherty, you can continue.
Thank you, Your Honor. So Stephanie, I would figure your photos are a true and accurate representation of the day that you took possession of property.
Yes.
I would move to admit these as Exhibit 1, Your Honor.
I object.
What are the grounds for your objection?
Same thing, because who did the damage?
Okay, I understand. I would overrule that objection, but in terms of foundation, counsel, you're appearing remotely on an audio-only connection. How are you going to lay the foundation for an exhibit? Has Mr. Macek been provided a copy? Help me understand from a foundational standpoint how I can admit this.
Oh, yes, Your Honor. I mailed a copy out this morning, Mr. Macek, and I lodged these photos with the court, the clerk, so they're either at your office or in transit to your office.
But that doesn't give me my pictures. I have no pictures.
I'm inclined to sustain Mr. Macek's objection. I don't even have the pictures in order to ascertain any foundational statement you're making, and you mailed them the morning of the hearing. So there's no way he would have ever gotten them. But I can't admit those photos at this hearing. I just don't think speculative photos don't constitute competent evidence. Evidence has to be competent in order to be admitted, so I'm going to sustain the objection on that point.
Okay, and I would, if need be, the hard part is Mr. Macek won't respond to email, so I'm not sure if he ever gets these exhibits when I email him two of their.
Well, I take your point, but in the best case scenario, no one in America has same-day mail service.
Yes, no, I understand, and if need be, maybe I'll.
I object. It's too late. There's no need be. He had his need chance. I had to play by your rules and jump through all your hoops for the original of this case.
I just sustained your objection.
I understand that, but that's in response to that.
So why don't you just simmer down? I listened to what you had to say, and I ruled in your favor on the rules of evidence. You're still mad, so...
I'm not mad.
Okay, then that's all I need to know.
Okay.
Mr. Flaherty, you can continue.
Okay, thank you, Your Honor. So, Stephanie, your understanding when the court issued the real property order, the respondent was responsible for paying for any repairs or damage due to his tenant occupancy, and that would carry on to the sale of the home, where he would have to take that responsibility. So, in order to, through paragraph 5, if you itemize those expenses that were caused by his tenant occupancy.
Yes.
How did you itemize those expenses?
I had a contractor come out and assess specifically only the damage to the home.
And did you change the condition of the home prior to having that contractor assess the damage?
No.
Once you had the tenants out, how soon from their removal to the contractor coming in?
Just within probably a few weeks.
Okay. And did the contractor find damage due to the tenant occupancy of the home?
Yes.
Objection. Objection.
Just one moment.
She's answering
Where's
for
the objection? What's your grounds for your objection?
hearsay. She's answering for the inspector.
I'm going to sustain the objection. Mr. Flaherty, can you rephrase the question?
What amount of damages were attributable to Jason's tenant?
$34,000. $800.
And I object to that. She doesn't have any kind of proof or evidence of what the damage or how the house was prior to even the renters being in there. If I see pictures of that too, then there's obviously damage, but there's no proof of carryover damage from prior tenants.
Mr. Flaherty, do you have any additional foundation for that question? Because absent additional foundation, I would have to sustain the objection. So is there any foundation?
Let me try and rephrase that so we understand what happened here. Ms. Frank, pursuant to the settlement agreement, Mr.
Which I object to through fraud, waste, and abuse as acquisition to that property because it was into my name.
That's overruled.
That's fine, it can be.
Overruled. So you can continue, Mr. Flaherty.
So, Mr. Frank has, or Mr. Mason has possession of that property pursuant to the settlement agreement that you and he entered into and was approved by the court.
Yes.
And did you ever meet the tenant or go over there or inspect the home after you moved out of marital home?
Yes.
I'm sorry, between the time that you moved out and the time that Mr. Mason had the ownership of the home, did you have anything to do with the tenant or did you ever go over there?
No.
So, to your knowledge, when you moved out of the marital home, was it damaged in the way that it was when you found it in 2019?
No, not even close.
Was it a fit and habitable home when you lived there in the marital home?
Yes.
And immediately after you left the marital home, who had possession of that home?
Jason,
And what was the address of that home?
451st Street South.
And Jason previously testified that he had rented it to tenants.
Yes.
And did you rent it to those tenants during that time, or did you have anything to do with that, that occupancy?
No.
So eventually, did you obtain ownership of that home?
Yes.
And
Illegal.
was there a legal mechanism that you obtained ownership?
Objection, yes. Fraud, waste, and abuse through the
I'm
system.
overruling the objection.
That's fine, it's heard.
Well, you can make your record, but
Oh, it will be made.
fair enough.
Public. Nationwide.
This is a public hearing.
That's fine. And it can go public.
You have constitutional freedom of speech.
I do.
You can disseminate the results.
And I will.
Your tone's argumentative, though.
No, it's not. I'm just talking back.
Well,
Monotone.
you
I'm relaxed.
you can proceed and you can make your record, and this is a public event. But I'm not going to tolerate an argumentative tone.
I'm not being argumentative.
Well, you are. But fair enough. Mr. Flaherty, you can continue.
So do you have personal knowledge, Stephanie, of when you moved out to when you became the owner again, that the condition of the house had changed?
Yes.
I object. There's no pictures to that.
One moment. So I'm going to overrule that objection because she's testifying to sensory information based on the foundation that she's provided.
Right, but
Well, let me finish. I'm ruling on your objection. She testified about her sensory perception at one moment in time when you first vacated the.
and I'm objecting to that.
Well, I'm overruling your objection and I'm making a record of
Okay.
why I'm overruling your objection. She has testified based on her own sensory information, which is not hearsay, and it's allowed in the rules of evidence based on her views of that locale at that time. So that's legitimate under the Montana rules of evidence, and I'm letting it in over your objection for those reasons. Mr. Flaherty.
So based upon the condition and how it changed,
And I'm going to object again to the other renters that she admitted to. She doesn't have documentation or pictures from that span or any damage.
Evidence is one method. Her sensory information is another method.
And admitted that she had never been there in between any other of the renters. She has no proof of who did the damage.
That'll be for you to mention at the argumentative phase, now we're at the evidence phase. So photos aren't in, her sensory information up till now is in. There
And were you able to communicate effectively what damage needed to be fixed from the time that you left the home as a marital home and the time that you reobtained ownership of the home to the contractor?
Yeah,
And did you give the contractor specific instructions to only look for damage items that were new and not a part of your marital home damage?
Objection.
Yeah.
How would he even know that?
That's overruled because she's testifying to what she told him. So the implication is he knows because she told her. You can argue against it later, but it's
No,
admissible under the
I got it. You said it perfect right there.
Okay.
That was perfect.
All right. This is clear.
And so what number of damage was attributable to the time that you were out of the marital home and the time you became owner of it again?
34,800.
And I object to
And
that
One moment. What's the grounds for that? One moment.
because I haven't received any kind of number or anything for this. Just like the pictures, how is that admitted for
But it's not
anything?
admitted. The pictures aren't admitted.
Exactly.
So,
That's what I'm saying.
I'm
I'm
gonna-
objecting to this
I'm
this
sustaining
this
your
price.
objection
Okay.
because what she knows of that dollar value is hearsay coming from the contractor. So I'm sustaining your objection on that point. That is inadmissible hearsay without other grounds. Mr. Flair, did you have other grounds to try to offer that, or you're going to admit that through the contractor himself?
the contract will be on in a minute, so I can do that there.
All right, so that is, that's sustained.
And then, so Stephanie, since that time, you have been working on the house and getting it ready for sale. What expenses that you had, and let's just go through it real quick. Were you able, the tenants,
I
they not pay
object.
rent, from September to
One moment, I have to entertain the objections in real time. Mr. Macek, what's your objection?
I have no list of what damages are going to be going over.
Well, neither party presented evidence to each other prior to this hearing.
I don't even know what this hearing is about. I just received a letter in the mail. Show up.
All right, just one moment. As I'm sitting here on the bench, I've been delivered petitioner's exhibits. So I'm getting them in the middle of the hearing, and Mr. Frank has not seen them. So here's what we're gonna do. In order to eliminate any due process concern for either party, I want to express to both parties the relief being sought by petitioner is they're asking me to find that you're in contempt for not following my order, which is laid out in the contempt statutes in the code. I can't give you legal advice, but I can outline the proceedings. So I want you to know what they're asking me to do, because I'm going to have to continue this hearing, because neither side has exchanged information about evidence. And I'm going to order both of you to do that. I'm going to ask Mr. Flaherty to give me a proposed order. And I know I'm going to have to set aside 4 hours for the hearing, because we'll have evidence and we're going to have argument. And everything that's in evidence now, you're not going to have to readmit. But I'm going to order the parties to exchange your evidence within 2 calendar weeks from today. Mr. Flaherty, are you writing this down? Because I'm going to need a proposed order on this.
Yes, Your Honor.
First of all, the hearing is going to be continued. Second, I'm ordering both parties to provide exhibits and witness lists in advance, and those must be mailed to the other party within 2 calendar weeks from today. So that when we resume this, I don't want to hear that someone sends something the day of the hearing, and you'll have the same obligation. I'm going to hold you both to it on both sides. So if you want to testify, you must list yourself as a witness.
I still don't know what this is about.
Well, I just told you what it's about.
No, you told me what you were
They're
offering
saying-
a continuance.
They're saying that you intercepted rent money by having the tenant
Oh,
pays
okay.
the bail, and they're saying that you never paid back the $1,800 deposit as they allege you ordered to do, and they're alleging that you're obligated at some level for this $34,800. So when we resume again, which will probably be in about 6 weeks or later, no one can say they're not on notice of what we're doing, because I've just told both sides in open court chance, Mr. Flaherty, is there any other relief that your client is going to be seeking later? Because I don't want to have a due process concern for either side.
Your Honor, the damages attributable to Mr. Macek's ownership, and then one half of the unreimbursed damages attributable to Ms. Frank's ownership.
All right. And sometimes I accidentally start to call you Mr. Frank because that's how I knew you earlier in the case, but I know you're Mr. Macek now, and I'm going to try to call you by the name that you've chosen to be known as. Mr. Macek, are there any other points of relief that you're going to be seeking at the later hearing? I want both sides on full notice of what's on the table here.
Sure, I mean, I want my property back, I want my kids, I want my pension that was illegally taken, I mean, all the fraud, waste, and abuse, I want this back for the first time you and I sat down across the street and talked.
I want to be candid, we're not going to...
That's fine, I understand that, but I'm just saying what I want.
Fair enough.
Okay.
But I want to be...
And there was no reason for any of that for the last 3 years.
It was based on the evidence. But
And I had evidence that proved that I was a great father, and you went with this. But it's all posted already. We already know about
Well,
that.
if you're going to be making
I'm
threats...
not. I'm not making threats. This is my request.
Fair enough. I want to be candid. Parenting rights can be relitigated in the state of Montana pursuant to section 44219, which governs changed circumstances. Absent of showing of changed circumstances, I'm not going to modify the parenting at this threshold of the case, and I'm not going to relitigate the underlying event. So the lines of battle are drawn. We're talking about, will there be remedies and penalties?
Sure, I want my property, I want my pension, and I want my kids. There you go.
Send your request, but that is not...
That's fine.
The issues are going to be more narrow than that.
Okay, fraud, waste, and abuse, that's pretty narrow.
All right, you've made your record. And with that, Mr. Flaherty, how long would you need to give me that proposed order in writing?
I'll do it in the next 20 minutes here, Your Honor.
All right, I appreciate that. This hearing is now adjourned. Court will be in recess.
Your Honor. Your Honor.
Yes.
Just one more point. This court...
I object because that was adjourned.
Just a moment. Let me listen to him, and then I'll listen to you. I don't even know what you're objecting to until I hear what he said, okay?
That's fine, you said adjourned.
Well, he said one more thing.
After the adjournment.
You're both going to have a chance.
That was his chance, pre-adjournment.
Well...
We all know how this works.
Let me just tell you. Probably 10 times a week or more at the end of a hearing after I say adjourn, someone says one more thing, and I let them...
And it's always been the plaintiff that has benefited from all the pandering. That's fine, it was adjourned.
I think...
Okay, well, I'll make my point. Objection, it was adjourned. Anything after this, fine, go ahead.
Well, I just want to respond to that. I think similar people in similar situations...
This has no similar situation. This is ridiculousness.
Well, that's your...
It's a lot more than just mine. This is truth and fact.
I let people raise another point after I said adjourn.
As long as they are, what, the lawyer or the plaintiff?
No, I have been extremely fair with self-represented litigants, and I've gone out of my way to ensure you're on a level playing field. The record will show that. With that said...
I object to that.
Fair enough.
As saying the record will show being fair?
Let the Montana Supreme Court will decide.
Oh, okay.
Fair enough. Mr. Flaherty, what do you want to tell me?
Was that a suggestion that this is going to go that far? Was that what you were saying?
That's up to you and Mr. Flaherty.
No, you just made the statement. I didn't know what was going on with that one.
You're making your record. The only reason to make a record is if you want to appeal, and you're legally entitled to appeal.
Yeah, but why would you say something like that? That's isn't that giving me kind of what to do?
You have legal rights.
I understand that.
Ruling.
Yeah.
Just as you can publicize the information. So I'm just being candid.
It sounds like you're just trying to wash your hands and say, go take care of it higher up in the Supreme Court.
I'm not washing hands. I'm going to take more evidence at the next hearing.
Okay.
But I stand on the ruling that I made.
Perfect.
Based on the evidence I've heard.
Which is either fair or unfair, depending on who you are.
And I'm a trial
And they shouldn't have to, though.
Well, that's the way the system of justice works across the United States.
Yeah, it doesn't. You're voted in. So that's okay, too.
Well, that's a matter under the Montana Constitution.
You're right.
So, at any rate, Mr. Flaherty.
Yeah, so, Your Honor, previously, a few months ago, Mr. Frank was noticed hearing for a restraining order, which was eventually granted. The Cascade County Sheriff's Office has not been able to locate Mr. Macek. He is behind a locked gate, but he did on July 8th come to the marital or the Stephanie's home and speak to the children. And the Sheriff's Office, without having record of service of that order, can't enforce that order on Mr. Macek. So I would just ask this court remind, or if there's any way we can get a better contact information so that order can be served, or Mr. Macek can be provided a copy of the order of protection to help protect Stephanie and the children, especially from all the Facebook comments that he makes about Stephanie currently with that order in effect.
I object. Because they're not comments. All that is the proof from 2017-18.
Are you going to willingly accept service of that court order?
Of a court order?
Of the order of protection. Are you going to willingly accept service, or do I need to request you give us a new address of the sheriff's office?
You have my address. They have my address. They've had my address since 2017.
So, Mr. Flaherty, his record statement is...
But their abuse of words is I'm in a locked gate community or whatever when there's a mailbox right out front that has the address on it. The P.O. box, which has been the only address since the beginning of this case until one time it got found out about over there. So I don't know why you guys are playing this mail fraud game when I have a P.O. box perfectly fine since day one. I'm not saying you, I'm just hitting it blanket. I'm blanketing this because we all know who's playing that game. And the envelopes will prove it.
Mr. Flaherty, are there other points or questions you have regarding service process?
No, and that Mr. Macek should be made aware it has to be personally served, so I can't leave it in the mailbox.
No, but you can give it first. First class mail gets in. I have to sign for it. You don't need to be present.
Well, as a matter of law, personal service is required, but...
Well, if that's the case, none of the mail that I've received has been personally delivered by anybody.
Personal service is required for the order of protection. It's not required for every document case. Mr. Flaherty, you'll have to make your own plans regarding service. So, I'll let Mr. Flaherty say a bit more. Mr. Macek, what else do you want to know?
This was adjourned 5 minutes ago.
All right. Court is now in recess.
All rise.
Get him?
What's that?
Get him?
No.
Oh, okay.
partner's mouth when he was walking out. He was mouthing and said, "Get him to the tin man. I could be holding the door." And then they all coalesced outside the door.
Fire pizza place, so I think I can probably stop recording. Yeah, 60 minutes in, so there we go. There was an hour of my time yet again wasted by the courts.